The Supreme Court's verdict is part of moves towards expediting governorship tussles in Nigeria. Legal practitioners have suggested punitive costs for lawyers who file frivolous motion as well as waste the time of the court. This, amongst many other suggestions, came to the fore shortly after the Supreme Court delivered judgment in 6 at the Apex Court on Friday. Correspondent John Felix has more in this report.
As the stipulated time for court judgment at the Supreme Court draws nearer, legal practitioners, politicians, and key stakeholders are already taking stock ahead the next election cycle. On Friday, the Supreme Court delivered judgment in 6 states, laying to rest every form of electoral dispute. While this lasted, the question on how long litigation should last up to the Supreme Court comes to the fore. What then can be done towards fast-tracking electoral dispute?
If we can activate the use of technology, it could fasten court processes. And number two, if we could avoid counsel filing frivolous objections or motions in court during tribunal and giving every punitive cost against any party that files frivolous motion. Such can also assist to reduce the number of days to be spent. Well, in all, because of the situation of the circumstances where the environment we find ourselves is almost difficult. We see even where court try to beat that 180 days, and we think it's almost impossible. However, it's very possible if political parties can start gathering their evidence right from when election is being conducted and prepare all documents even before the petition is being filed and the process is being fast-tracked. I think we can even have a lesser period than the 180 days. It's possible.
All these, looking at it holistically, definitely would still warrant us looking at the Electoral Act squarely for some probably shaking up and accommodation of some of these little excesses that we have seen that might not actually, the time frame might not be enough to address all these issues brought before them. And don't also let us lose sight of the fact that some are sitting where we even have internal crisis, whether caused by whether is the usual challenges we have in this court, which is insecurity, banditry actions that the court might not be able to sit at some point. They might delay. Some even shifted from the jurisdiction to another jurisdiction to sit. Logistics, all that would definitely eat into the time. I don't think the Electoral Act anticipated that. So all these we have to look into it and make provision, because some will say that even the final arbiter are decided, but is it really a just decision?
Now that the vast majority of the governorship dispute has now been laid to rest, what lessons can the judiciary, Nigerians, learn as preparations for the next electoral cycle get underway?
And it's somehow embarrassing because even the blind can see and the lame can, the deaf can hear about some of these authorities which are already they are already locus classicus in our laws, and is already known fact. And now when the Court of Appeals judges are trying to obtain some of these authorities, it makes some of us feel bad, and it makes possibly contradictory opinions on some of these legal matters and issues. So if there is this position that all courts should follow the decisions of the Supreme Court, there won't be any need for frivolities. Then the matters will just be expedited and we get the result as fast as possible.
If in truth we vote as per our conscience and not as per who is buying what, then I think it will reduce drastically, because from that is the foundation where we actually are going. We'll be going to the poll to actually elect by conscience. Most of the time, people would have known that, see, I'd won or I'd lost squarely. It happened during MKO. People knew the vote actually was casted, and they knew. So it was so difficult for anybody to even start challenging anything. So where if we get it right from that angle, it would have reduced the whole shortfall that we'll be having in any form. Then going back to electoral umpire, which is INEC, there are a lot that INEC also need, because in some instances where we have some of the contestants challenging that, a particular area there were votes that were illegally removed, the provision of the law, if some certain things are not done, okay, you cannot add that vote, you understand? Or okay, there are reasons why you can only declare a particular polling unit inconclusive, or there are but sometimes we realize that we use a particular how can I put it now? We implement as per what we feel per time.
With the pronouncement by the Supreme Court, perhaps the time for a closer look at the Electoral Act may just be now. From Abeokuta, the State capital, John Felix reporting for Galactic Television News.